5634 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5634, to increase the number of manufacturers registered under the Controlled Substances Act to manufacture cannabis for legitimate research purposes, to authorize health care providers of the Department of Veterans Affairs to provide recommendations to veterans regarding participation in federally approved cannabis clinical trials and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. The Controlled Substances Act and 2 international treaties provide the framework within which Schedule I drugs, including marijuana, are grown, manufactured, and researched. Federal law also requires that before a new drug is allowed to enter the U.S. market, it must be demonstrated through adequate and well-controlled clinical trials to be both safe and effective for its intended uses. Long ago, Congress established this process, recognizing that it was essential to protect the health and welfare of the American people. Until 2 months ago, no drug product made from marijuana has ever been shown to be safe and effective for human consumption. In June, the Food and Drug Administration, for the first time, approved a drug that contains a purified substance derived from marijuana, Epidiolex, an oral solution containing pure cannabidiol, was studied for several years, during which scientific studies and supervised human trials were conducted and showed to be safe and effective. DEA is expected to act soon and allow this drug to be used for the treatment of seizures associated with 2 rare and severe forms of epilepsy in patients 2 years of age and older. This demonstrates that the current system and implementation of the law is effective. It ensures that valid and compelling scientific evidence is behind every safe and effective drug. Federal agencies, including the Drug Enforcement Administration, the Food and Drug Administration, and the National Institutes of Health, all support research into the potential medical utility of marijuana and its chemical constituents. There are a variety of factors that influence whether and to what extent such research takes place. Some of the key factors, such as funding, are beyond the control of enforcement and regulatory agencies such as DEA. However, one way this committee and Congress can help to facilitate legitimate research involving marijuana is to take steps within the framework of the CSA and U.S. treaty obligations to increase the lawful supply of research-grade marijuana available to qualified scientists. H.R. 5634 has a very narrow scope and is designed to facilitate and encourage qualified researchers to develop valid, verifiable scientific evidence about the potential medicinal value of marijuana. It increases the number of federally regulated marijuana manufacturers solely for research purposes. It also allows the Department of Veterans Affairs healthcare providers to discuss with veteran patients their participation in federally approved marijuana clinical trials. No matter where each of us may fall on the issue of marijuana, this bill takes a reasonable and balanced approach toward ensuring marijuana, and particularly the over 100 cannabinoids it contains, can study by qualified researchers and institutions in a controlled manner to determine whether those substances have actual legitimate medical uses. The science derived from this research could improve the lives of citizens and even save lives. We should not be afraid of science. I urge my colleagues to support this bill. It's now my pleasure to recognize the ranking member of the Judiciary Committee, Mr. Nadler of New York, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, although H.R. 5634, the Medical Cannabis Research Act, is intended to be a modest but helpful measure to address certain restrictions on the manufacture of marijuana for research purposes, unfortunately, I must oppose it because it would unfortunately and unjustly expand the collateral consequences of criminal convictions. We know that marijuana can be effective at alleviating pain, suppressing nausea, and treating conditions such as post-traumatic stress disorder. Although continued and expanded research is necessary to further examine the potential benefits of marijuana, there are legal and practical limitations on the ability of doctors, scientists, and academics to conduct this research. Largely because marijuana is inappropriately categorized as a Schedule I drug under federal law, there is an onerous and cumbersome process for obtaining federal approval to conduct research. Currently, there is only one entity that is registered and approved by the DEA under the terms of the Controlled Substances Act to manufacture or grow marijuana for research purposes. Researchers indicate that, unfortunately, the supply of cannabis made available by the University of Mississippi is frequently of low quality and moldy, which can cause illness. In recent years, many states have legalized marijuana for medical purposes, and a few others have legalized it for recreational use. There have also been discussions within the executive branch about taking steps to approve more registrants to manufacture marijuana. However, at the present time, the University of Mississippi remains the sole approved manufacturer of marijuana for research. To address this concern, H.R. 5634 would require that there be at least 3 federally approved manufacturers of marijuana for research purposes. This is not a vast expansion, but it would help to address the limitations on the availability and quality of marijuana for research. I am disappointed, however, that the bill includes a requirement that each person involved in a manufacturer's operation undergo a background check to confirm that they have no felony or drug-related misdemeanor convictions. As this committee seeks to engage in criminal justice reform, and particularly on the day when we consider the Second Chance Act, we should not include such a requirement that would expand the collateral consequences of criminal convictions. For decades, drug laws have been disproportionately enforced against minorities. This is particularly true with respect to misdemeanor drug convictions. Now, when we are allowing a limited number of people to financially benefit from the legal growing of marijuana, we should not compound this injustice by preventing the very people who have been harmed from participating. The bill includes a broad restriction based on any felony committed at any time. It also includes mere misdemeanor drug offenses committed at any time. These restrictions are sweeping, unwarranted, and unjust. Also, the bill would clarify that the doctors and staff of the Veterans Administration are not prohibited from sharing information about federally approved marijuana clinical trials with patients. If there are trials that may help our veterans address their needs with regards to pain or PTSD, VA officials should not be prevented from sharing this information, and I would endorse such provision in a bill that I could otherwise support. Even if the committee adopts this bill today, there is more we must do to address the legal status of marijuana in this country. Continuing to arrest and incarcerate through enforcement of outdated marijuana laws, often in a racially disproportionate manner, is a disgrace. One of the unfortunate aspects of such enforcement is that those convicted face an array of collateral consequences, including difficulty obtaining employment. Therefore, although I would very much like to support a measure that would help provide more marijuana for research purposes, I cannot support this bill because of the overbroad restrictions regarding convictions. If this is not addressed by amendment, I will have to vote against this bill today. I yield back the balance of my time.
Thank you, Mr. Nadler. I'd now like to recognize the sponsor of the bill, Mr. Gates of Florida, for his opening statement.
Thank you, Mr. Chairman, and I'd like to begin by thanking Chairman Goodlatte and his staff for being faithful to their commitment to work with our office and a number of the bipartisan members of this committee who have a desire to advance the cause of cannabis reform. I have to say, I never imagined that in the 115th Congress, I would be in this committee with Chairman Goodlatte advocating for the advancement of cannabis reform legislation and the ranking member advocating against this particular bill. That has baffled me, but I do want to acknowledge the tremendous contributions and encouragement and assistance that members from both parties have provided on this issue, and regardless of the vote, I am very grateful, and I fully agree with the ranking member that the cause for cannabis reform will require continued effort and energy and focus if we have been imprecise in any of the details in such a new frontier that we are embarking upon. I want to be very clear as to what this legislation does and does not do. It does not remove cannabis from the list of Schedule I drugs. It does not make medical cannabis available to even one additional American. What I think it does do is demystify the debate we're having about medical cannabis. It is very frustrating to advocates for cannabis reform that when people who oppose our views say, well, there's no research to prove that this works, to live in an environment where the federal government's policies frustrate that very research. It creates a catch-22, and so here's what the bill does. First, it ensures that there is a sufficient supply of medical-grade cannabis. Right now, only the University of Mississippi is growing research-grade cannabis. It's sort of the government cheese of medical-grade marijuana. And I think we could do a lot better and unlock more cures if we had that expanded availability of research-based cannabis. And so I'm grateful that this legislation would require that of the Department of Justice and not give the Department of Justice the discretion to suppress the quantity of research-grade product. Second thing the bill does is create a safe harbor so that the very best and brightest minds in our country can begin working on unlocking these cures. Today, actually, we held a field hearing recently where people from Penn State University came and said as a consequence of new state laws in Pennsylvania, there's a real desire for the university system to collaborate with private sector researchers, with healthcare providers, and to be able to determine which strains and which therapies are effective, what dosage levels help people or don't help people, to be able to chronicle that information and to be able to present it in a research-based acceptable setting. But that is illegal today. They can't do it at Penn State or at the University of Florida or any other number of universities. So this legislation creates a safe harbor for universities, for medical institutions to be able to engage in that collaboration. Third thing the bill does is demystify the process we have now at the VA. I'm incredibly proud of the work that our colleagues on the VA committee have done so that veterans can become more aware of federally approved clinical trials. But unfortunately, that has been administered very inequitably, where in some places veterans are given that opportunity, and in other places, just as a consequence of local practice or culture, veterans aren't made available of the federally approved research that could help them. And so this legislation incorporates the work of the Veteran Affairs Committee and would advance that forward so that we can ensure that that process is more effective for the veteran and for the scientific community. If we do just these modest things, I think we can have a more adult debate. I am sensitive to the concerns that the ranking member raised. I will acknowledge that more work could be done to appropriately tailor the criminal prohibitions to the allowances for additional research work. I don't think that we've sharpened the pencil on that enough. But I would plead with my colleagues, please do not allow this to be the last opportunity we have to collaborate in this important space. It has taken a year of the 115th Congress to be able to get to this point where we have some bipartisan agreement on at least unlocking the research so that we can learn more and have more robust debates about whether or not broader application of medical cannabis is needed or authorized or even could be facilitated by the government. We're not there yet. I am hopeful that we'll be able to get there with a bipartisan vote of the committee. Again, I thank the chairman for his diligence and his fidelity to his commitment, and I thank the members on both sides of the aisle who have been so encouraging and supportive to this point. I yield back.
Chair, thanks, gentlemen. I would ordinarily now recognize the ranking member of the subcommittee, Ms. Jackson Lee, but she's not here. For the purpose of the gentleman from Tennessee seek recognition.
I have an amendment at the desk.
The gentleman is not recognized for that purpose. For the purpose of the gentleman from Florida seek recognition.
I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 5634, offered by Mr. Gates of Florida. Page 5, line 21.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This is merely a technical amendment that identifies the type of law enforcement that would be necessary for a research application to proceed, and it corrects a date that was improper in the original drafting. That's the amendment. I yield.
The gentleman yield.
Yes.
I support this amendment. The August 2017 date places an appropriate time limit for prospective applicants to have applied for a marijuana manufacturing registration pursuant to the 2016 Federal Register notice. The addition of local law enforcement to those who must certify the good standing of the prospective marijuana manufacturer assures that local citizens and government officials have input and participation in this process. For purposes, the gentleman from New York seek recognition.
To strike last word on this.
Gentleman's recognized.
Thank you, Mr. Speaker. Mr. Chairman, I support this amendment because it would extend the date for the acceptance of applications and therefore would expand the applicant pool, and it would modestly improve the requirement concerning the letter of good standing that applicants must submit from health and law enforcement agencies. However, I remain concerned, as I said, that the amendment does not address my concern about the restrictions concerning felony and drug-related misdemeanor convictions. But nonetheless, the amendment is good as far as it goes. I yield back.
What purpose the gentlewoman from Georgia seek recognition?
Move to strike the last word.
Gentlewoman is recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in support of this amendment and this overall legislation and want to commend both the chairman and especially my colleague, Congressman Gates, for your incredibly hard work on this important issue. Your dedication is really commendable, and I thank you for that. This bill represents a very critical step in gathering the information that is needed to address this issue. Research into the effectiveness of medical cannabis has been significantly limited by access to the product. There is only one federally licensed facility allowed to produce marijuana plants for the research. As a result, researchers face significant hurdles in accessing the medical-grade cannabis on a consistent basis. In Georgia, through the leadership of my good friend, State Representative Alan Peake, Georgia enacted a law that allows medical CBD oil for patients facing certain serious medical issues, and I want to commend Representative Peake along with the tireless advocates who have really been front and center in bringing this issue to the attention of elected officials like myself and those of us on this body. I think we all would agree, however, that additional research really is needed to fully examine the effects and merits of medical cannabis on a wide array of illnesses. Congressman Gates' legislation will indeed expand the research opportunities by requiring the Department of Justice to approve at least 3 applications for the production of medical-grade cannabis. With this bill, researchers will have ample opportunity to examine the potential, the further potential of medical benefits and be able to identify viable and effective treatments for additional variety of conditions. This legislation is a very positive and important step forward. I urge my colleagues to vote yes on this bill. Thank you, Mr. Chairman. I yield back.
Chair, thanks, gentlewoman. What purpose the gentleman from Tennessee seek recognition?
Strike the last word.
Gentleman is recognized for 5 minutes.
Would Mr. Gates yield for question? What would this leave as the standard for local law enforcement? What standard would they have to use to determine that somebody is an upright, good citizen, et cetera?
The amendment doesn't clarify the standard. It merely indicates that federal law enforcement would not be able to stand in the way of that certification.
Is there a standard in the bill?
There's not.
So it's just will and caprice of the local law enforcement to decide you're good, you're not good, you're good, you're not good, you're not good, you're not good, you're not good.
No, that would be arbitrary and capricious, and that would be illegal.
So that's why we have standards in bills, so things are not arbitrary and capricious. Why don't we have a standard by which the local law enforcement person can make that determination?
The implied standard, though I would concede could seek clarity, the implied standard would merely be that there were no laws being broken at the local level by those people. Everything from if you had someone build a grow facility that violated the zoning code to whether or not you had other illegal activity occurring, the existing standard would be the existing criminal code.
So any violation would eliminate. So if you were convicted of DWI or if you were convicted of IRS violations, you couldn't participate?
No. You're confusing the standard for the certification of the entity with the people who are engaging in the research. So the business entity, for example, could be outside of legal compliance, whereas the people could be fully compliant who are in fact the applicants. So the certification requirement is merely a certification that there are no laws being broken pursuant to the local law enforcement officials at that time at that property.
Would you read me the clause that you're referring to about the local law enforcement? I may be wrong, but if you'd read it to me, I'd appreciate it.
Yeah, again, the local law enforcement provision is not in the bill, it's only in the amendment. And so it'd be page 5, line 21.
But the previous, what you're amending,
yeah, I don't have that.
Is federal or local, and what does it say? The federal or local shall what? Shall authorize, okay them, shall approve them?
Right, shall merely be a part of the application, I believe is the requirement in the bill.
Be licensed by the state. Have completed a criminal background check for all personnel involved in the operations of the manufacturer pursuant to this section, and to confirm that such person have no conviction for a felony or drug-related. Is that the extent of it, number 8?
If the gentleman would yield.
Yes, sir.
The amendment does not refer to page 5, line 13, which is section 8 it refers to page 5, line 19, which is section I, which reads, have a letter of reference affirming the manufacturer's good standing from each of the applicable state healthcare and law enforcement authorities in each jurisdiction of the manufacturer's operation pursuant to this subsection. And he simply adds state healthcare and the following, quote, local. So it's addressed, as he indicated in his response to you, it's addressed at the facility, not at the employees.
Thank you, Mr. Chairman. Let me ask you this. What does it mean by the manufacturer's good standing? Does that mean that they haven't been convicted of anything?
No, Mr. Cohen, that merely means that they are in good standing at that time for that purpose. For example, if you had a medical director who didn't have their medical license, but you listed them as their medical director, that would not be good standing for the sake of the application. For specifically the law enforcement provision, it's are you breaking any laws at that time pursuant to local law enforcement at that location?
Thank you.
The question occurs on the amendment offered by the gentleman from Florida. All those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it, and the amendment is agreed to. For what purpose the gentleman from Tennessee seek recognition?
Amendment at the desk, sir.
Clerk will report the amendment.
Amendment to H.R. 5634, offered by Mr. Cohen of Tennessee. At the appropriate place in the bill, strike or drug-related misdemeanor.
Without objection, the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman, and to you and the sponsor and all the members. I'd like to see this bill pass. It does no harm. It doesn't do nearly as much good as it could do if we went further, because there's a problem with marijuana being a Schedule I and the difficulties of getting a research study started being a Schedule I facility, and that involves the upgrading of lab facilities and security protocols, which are difficult as well, and getting DEA approval. But this might help, it can't hurt, but there's no reason to limit people who have been convicted of marijuana possession in the past. This is a scarlet letter that should not be on a person forever. And because somebody smoked marijuana, it just means they're one of tens of millions of tens of millions of tens of millions of Americans. Probably a third to more of the people in this room who have sometimes smoked marijuana. And to say that they couldn't participate is just to continue a canard that has gone on since Harry Anslinger in the 30s, that only foreigners, people from Mexico or African-American jazz musicians or other quote-unquote undesirables smoke marijuana. That was the basis of the law that made marijuana illegal in the first place, were canards and racial prejudice that was spread by Harry Anslinger and perpetuated by others who needed jobs and security, and Richard Nixon, who needed a political victory. Even though he knew it was false, he spread those canards and had a war on drugs and was told that marijuana should be legalized and didn't do it because it was politically good for him to keep it illegal. The chairman in his opening remarks said there have been no studies to show that marijuana is an effective and safe drug for human consumption. Mr. Chairman, there are tens of millions of tens of millions of tens of million American stories who by practice show you that marijuana is safe for human consumption. This is not a need to reinvent the wheel. Nevertheless, to say that somebody has been convicted of marijuana possession should disqualify them for a job in perpetuity is just wrong. Now, if you had something in here that said they had been convicted of theft, there'd be some basis for it in due process. Because if somebody's shown that they steal and they're working in this area where you've got an opportunity to possibly steal marijuana and use it or sell it or treat your friends, then it makes sense. But because you've been convicted at any time in the past, doesn't make a lot of sense. I'm not sure if people convicted of DUI or buying alcohol when you're a minor can never work as a server in a restaurant or work in a liquor store or something to that effect. I would hope that we wouldn't continue this idea that somebody once convicted of marijuana possession, which can cause them to lose student loans still, to lose federal housing, should be here as a prohibition from employment and a scarlet letter, a big M on your chest. So I would ask yield to the sponsor of the legislation and ask him if he doesn't concur with that and if he would not accept it, and then we could move on and possibly pass this bill.
I appreciate the gentleman for yielding. I very much concur with the sentiment of the amendment, just as I'm certain that the sponsor of the amendment concurs with the sentiment of the bill. The objective in drafting this bill was to find the broadest area of agreement. And I know that the sponsor of the amendment is sincere because the sponsor of the amendment is a co-sponsor of the bill, was an original co-sponsor of the bill, and was a co-sponsor of the bill when it contained this prohibition that the gentleman from Tennessee now objects to. I think that proves the point that there is more work here to do. The ranking member was correct about that in sharpening the pencil. Unfortunately, I cannot accept the amendment at this time because I've not had the opportunity to discuss it with other members of the committee, with other co-sponsors who have been part of the drafting process. And so I would ask the sponsor of the amendment, certainly, make your points, debate the amendment, vote for it, but I would just hope that if the amendment is unsuccessful, solely by function of time and inability to really come to consensus on it, that doesn't impair our progress moving forward. I yield back.
Let me ask you another question. What's the purpose of having this in here?
The time of the gentleman has expired. The chair recognizes himself so we can continue this discussion.
Thank you.
It's fully appropriate that we set a firm standard for those who are supposed to be growing and manufacturing research-grade marijuana. However, I hear the gentleman's comments, and I think there may be some common ground here. I don't think the language that the gentleman has, quote, or drug-related misdemeanor, there can be lots of things that are, quote, drug-related that are misdemeanors that might not be acceptable. There might be simply mere possession that might be acceptable. So I'll have a suggestion here at the end of my remarks, but these individuals will be growing and making chemical extractions from thousands of kilograms of marijuana each year. The actual license holder, the registrant, will very likely be a corporation which DEA and state and local authorities will have jurisdiction over. We should give that license holder clear standards and expectations for their conduct and the conduct and backgrounds of their employees. We are talking about a very small number of prospective employees who should have excellent backgrounds. Legally, I am concerned about efforts like California Proposition 47 and others, where states are legislatively turning drug felonies into misdemeanors. What is a felony in one state could be a misdemeanor in another. In this situation, making a distinction between the two is not appropriate. If we are serious about developing quality scientific evidence about marijuana, then those growing and extracting from marijuana, the object of that science should have and maintain reasonable background standards. But I would make this offer to the gentleman. If he's willing to withdraw the amendment, I have no idea when this bill is going to the floor, and the gentleman from Florida is quite right that this is a consensus bill that's going to take a lot of effort to get to the floor, and we don't need to create problems like this at this stage of the process. If the gentleman will withdraw, however, I would be more than happy to work with him to see if we can find some language that would address some of the concerns he's expressed, because if you're simply talking about somebody with a possession under certain circumstances, I would probably not object to that. But drug-related misdemeanor can encompass all kinds of things, many of which I would object to. So I'll make a bona fide offer to the gentleman to work with him if he'll withdraw the amendment and we can proceed forward, because the next step, once this bill leaves this committee, will be to get agreement to taking it to the floor, and what language is in the bill is going to make a big difference in that regard. So I will work in good faith with him because I respect his concern, and I also respect his underlying support, which I heard many, many times earlier in this Congress about wanting to do something in this area. I do too, but we're coming at it from different perspectives, and we need to work on that if we're going to succeed.
I appreciate that, Mr. Chairman, and you've always been honest and honorable on these, working with folks as you did with Mr. Gates and myself on this, and pledged to do that. Would we work together before it got to Rules Committee?
Yes, my intention would be to see if we can find language that we can agree to that would incorporate into the bill in the form of.
So that possession alone would not be a prohibition.
I don't want to define exactly, but I think it's going to have to be a lot more language than you have in these 3 words.
I will accept your offer and hope that we can go forward. And you're right, you have heard from me in the past. I've been for this before Country Joe and the Fish were for it. Thank you.
Will the chairman yield?
The Chair thanks the gentleman.
Chairman yield?
If the gentleman has withdrawn the amendment, then we can recognize.
Just, Chairman, would you yield just to your point? Just
Yes,
a
sir.
question. I appreciate your position, and it's my hope, and I appreciate Mr. Cohen doing this, that before it went to rules, we could enumerate just suggested crimes that we hope would be excluded. And I think the case of a simple possession, of marijuana would be one of those. And of course, there's others. But as this committee has taken on criminal justice reform, we would hate to see someone who had a simple possession, and then this bill is passed and it becomes law, and they're not able to, participate in this new economy.
That would be my general expectation. There are, as I noted, different definitions of what a misdemeanor is in different states, and there are also other circumstances surrounding the misdemeanor. There may be other crimes involved that occurred at the same time. So I think we need to study that carefully, and I'm prepared to do it quickly, because if we can bring this up to the floor soon, I'd like to bring it to the floor soon. But in either case, in order to get it to the floor, we're going to have an agreement on this, or it's simply not going to get there.
Do you yield back?
Mr. Chairman.
First gentleman from New York, seek recognition.
Strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I regret that I cannot be so accommodating. When we're under current law, research on marijuana is permissible, which it ought to be. The problem is, and the DEA can recognize as many different facilities to grow and manufacture marijuana as they see fit. Unfortunately, they've seen fit to do only one, which the quality and quantity of the product of which is not sufficient for the research. So we have this bill, which is a very modest bill, to mandate the DEA to allow at least 3 not research facilities, at least 3 producers of marijuana for research. It's a very modest bill. But under current law, the research, I keep saying research facility, I mean the production facility, the growing facility, does not have the restriction that says people who've been convicted of misdemeanors cannot work at the farm or the production facility, which is really a farm. Now we would impose that. We would impose some sort of restriction on misdemeanors. I feel, frankly, any restriction on misdemeanors goes exactly in the contrary direction as we will be going in, and the Second Chance Act will be taking up a little later this morning. There is no reason for it whatsoever, and we should not be establishing these kinds of controls on misdemeanors. The fact is that people who are convicted of a misdemeanor regarding a drug-related misdemeanor, that could mean giving it to your friend when you're 16 years old, should not be tarred, and the farm should not be limited in who they can hire to grow the research. If we're concerned, I mean, what is the possible concern? That someone of ill repute, of bad character, is going to divert some marijuana, perhaps, from this farm to other uses. Now, of course, we know there's a complete shortage of marijuana in this country. There is no source of marijuana for improper use other than this 1 or 3 farms. That's absurd. That's absurd. So the danger is negligible, and we should not be going further in putting prohibitions on people convicted of marijuana or drug-related offenses, especially when we know that this is historically, for the last since before World War II, when this stuff came in, these laws came in, it's been used for racially disparate purposes. So I would hope that we could have an amendment to get rid of this misdemeanor provision. If not, I cannot support the bill.
Will the ranking member yield?
Sure. Yes, I will.
There was a question that Mr. Cohen asked that I wasn't able to answer that I think goes to your point. This provision that you're concerned about, and to which I think you and Mr. Cohen have both raised reasonable concerns, was not a provision of an early draft that the chairman and I worked on. It actually came from the industry, interestingly enough. People in the industry are increasingly concerned that as they work on high-end, high-tech therapies, that the industry may look to outsiders and even to policymakers like just a bunch of people who wandered out of their drum circle or their hacky sack, endeavor. And so people in the industry wanted to raise the bar to legitimize the research work that they're doing. I will concede that I believe the current language may have overshot that mark. I believe the chairman has conceded that point as well. And just as original co-sponsors of the bill from the minority party who have been so helpful may have missed that overshooting of the mark when signing on, just as I may have missed that, I'm hopeful that we'll be able to work together, but it would really blunt our that is a terrible, terrible use of the word. It would really impair our progress if we were unable to pass the bill. So again, I thank the gentleman, but I at least wanted the gentleman from New York to know that the genesis of that provision was not the chairman. It was not even from any member.
Reclaiming my time, fine, but I'm really not concerned about the genesis of the provision. And the integrity of the research, I mean, let's be real. The integrity of the research will be determined by the quality of the product of the research. Scientific research is peer-reviewed and in journals and so forth, and that will determine how honest and accurate the research is, not who does the research, and not who works. We're not even talking about who does the research. We're talking about who grows some of the materials for use in the research. So it really has nothing to do with that. And I certainly support, I entered politics in 1977. I supported decriminalization of marijuana in the state legislature when we passed it a long time ago. I thought we'd be well past where we are now. But we should not be going backwards on tarring people for previous misdemeanor convictions or drug-related misdemeanor convictions, which probably should never have been misdemeanors anyway.
Yield?
Sure.
In New York State, I don't know if they have it. In Tennessee, they've got drug paraphernalia violations, which are misdemeanors.
Yes.
And if you're arrested with papers or something or not like that, it can be would you think that also should not be a prohibition, that you may have a conviction for having rolling papers?
Yes, I think, to reclaim my time, yes, I think any such convictions are irrelevant to who is qualified to be a farmer in farming the marijuana, period. I think it's completely irrelevant, and we should not be going along with expanding the collateral damage of someone who may have been convicted of something years ago. It's just the wrong thing. It's the wrong direction. We're trying to go in the other direction with the bill we'll be taking up a little later today, the Second Chance Act. And I don't see why we should be expanding it in this bill.
Would the gentleman yield?
Sure.
And without objection, the gentleman is recognized for an additional 3 minutes. What is the harm in working to fine-tune this language? Because, as I noted, in some state, drug-related misdemeanor could be possession of a large quantity of marijuana that's not for personal use. In another state, it could involve a drug other than, in fact, I would assume, given this language, in every state, it could involve a drug other than marijuana. It could involve an opioid.
Reclaiming my time, the answer to the question, I mean, your question is clear. I'm sorry, go ahead.
I just want to make this last point. That calls into question the integrity of the individual that's involved here. So I think we can probably find some common ground. I do not think we're going backwards because we're moving forward, allowing research on marijuana. And let me just be very clear. I would never have agreed with you on the legislation you introduced in New York to decriminalize marijuana. I do not support decriminalization of marijuana. I support finding out whether this particular plant contains substances that can help people cure diseases, maybe save lives. That's my purpose in doing this, which is different than your purpose.
No, it's not. Well, first of all, it wasn't my bill, but it was passed in 1977. It's been the law for 40 years, and New York has survived.
I would still be opposed to it.
Okay. In any event,
Mr. Chairman.
in any event, let me just say, even if, as is clearly the case, a misdemeanor may include these different types of more serious crimes that you said, the principle is that someone who is convicted of a crime, certainly a misdemeanor, I won't even debate felonies here, we're not talking about felonies, someone who's convicted of a misdemeanor and served this punishment or whatever it was, should not have separate collateral penalties preventing his employment or other things. Now, if you could point to some particular danger, what is the danger? Someone who sold marijuana on the black market, let's say, now might somehow do something wrong while growing the marijuana. It's certainly not going to affect the integrity of the research. The integrity of the research is determined by the research, by the quality of the research, and by the papers that are done, and you judge it. And the fact is that scientific research may be done by people of excellent or terrible moral standards. You judge the research by the quality of the research, not by who did it. So this, I would love to support this bill, but expanding the collateral damage for someone who's paid his penalty, especially for a misdemeanor, is going in the wrong direction, and we shouldn't do it.
Mr. Chairman. Mr. Chairman.
First, the gentleman from California.
Move to strike the last
Gentleman
word.
recognized 5 minutes.
Chairman, I'll be brief. I support the gentleman's bill. I think that we are arguing about the word yes. And what I mean by that is, as the gentleman from Florida aptly said during this colloquy, what we're debating is, for the most part, regulated by the states. And I believe that we can get to language that recognizes that states already are going to regulate if somebody wants a license to operate. Just as my state does not allow you to be a certified public accountant or a lawyer if you've been convicted for embezzling, because it's a fiduciary position, it is primarily these kinds of decisions which are state in nature. And since we are not actually creating a federal right, but rather a waiver for a state under usually federal grants to do certain work, I think what we have to do is trust each other that if we pass this bill today and work to get common language, we have a real opportunity to get this out of the House and make law. And our greatest goal today should be, since we all in various forms are at yes, that we simply get to yes today, get this bill out, and realize that the gentleman from Florida, the gentleman from Tennessee, the gentleman from New York, and the gentleman from Virginia have found a compromise that I think is historic in moving the research that I personally believe it's a scandal not to have, and have in vast amounts. So with that, I thank the chairman and I yield back.
Mr. Chairman.
Are there further amendments to H.R. 5634? For purpose, the gentleman from Rhode Island seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to associate myself with the remarks of the ranking member about the danger of creating additional collateral consequences for people who have a misdemeanor drug possession. And I hope that as efforts are made to work out the language, that the parties that will be negotiating this will keep in mind two other factors, and that is the substantial evidence that there is a significant difference in the number of African Americans, for example, who are arrested 2.5 times more often than white people, even though their use of drugs is at a similar rate. So there are racial implications of this kind of disqualifying language that I hope the parties will be very conscious of. In addition to that, the ACLU and their correspondence raises another issue which I think should be of concern to everyone. If a university ends up being the research facility and manufacturer, one could imagine that someone could argue that no one at the university then could have a drug-related misdemeanor. I mean, because that could be a custodian who cleans up the buildings. It could be someone who mows the lawn. So I think as you think about the language and what the implications might be, thinking about that disqualifying language, how it may have the impact on.
Would the gentleman yield?
Sure.
We will certainly do that as we work on that.
Yeah, I mean, I think that's important, and the racial impact of these kinds of disqualifying factors is important. And finally, to Mr. Nadler's point, adding another penalty to someone who has had this sort of an offense, when you look at the millions of Americans who've been incarcerated for drug possession, I think, again, this sort of fundamental question about, is there a public policy, is there a health or research legitimate justification for this kind of exclusion? It seems to me there is not. And as Mr. Nadler says, the research will be based on the quality of the research and on the controls that are in place for the research to be done successfully, and the prior offense of one of the people who are connected to it in some way is not a legitimate justification for excluding a whole group of people. So I hope you'll be vigorous, as I know Mr. Cohen will be, in those discussions to arrive at the right language. And with that, I yield back.
For what purpose the gentleman from Idaho seek recognition? I'm recognized. The clerk will report the amendment. You have withdrawn your amendment. Yes. He's been recognized for an amendment, and the clerk's going to report the amendment.
Amendment to H.R. 5634, offered by Mr. Labrador of Idaho. Add at the end the following.
Without objection, the amendment is considered as read.
Thank you, Mr. Chairman.
5 minutes on his amendment.
This is a simple amendment. It won't take me very long. All we're asking for is for the National Institute for Drug Abuse, in coordination with the FDA and the DEA, to develop and publish recommendations for good manufacturing practices for growing and producing marijuana for research. And with that, I yield.
Gentlemen, yield?
Yeah.
This is a good amendment which will help researchers develop the science and evidence toward the medical potential of marijuana, and I urge my colleagues to support it. I yield back to the gentleman.
Thank you, and I yield back.
First, the gentleman from New York seek recognition.
I see no reason not to accept this amendment.
The question occurs on the amendment. For purpose, the gentleman from New York seek recognition. Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I just wanted to speak on the previous discussion. One, to commend Representative Cohen for introducing the amendment. Thankful to my colleagues on the other side of the aisle for considering the urgent need to address the possibility of collateral damage that can be done to Americans as a result of the potential racially disparate impact of prohibiting people from participating in research based on prior convictions that they may have. New York City is often known as one of the more progressive places in the country, but I'm ashamed of the fact that it is also the marijuana arrest capital of the world. More people in New York City over the last decade or so have been arrested for simple possession of marijuana than in any other place in the world. And the unfortunate part about that, even in a place like New York City that prides itself on social, racial, economic inclusion, is that a disproportionate number of the people arrested are Black and Latino. Even though everyone acknowledges that whites use marijuana at the same or equal numbers than African Americans and Latinos in New York City and across the nation. Yet it appears, based on the fact that more than 80% of the arrests for possession of marijuana, misdemeanor possession of marijuana in New York City, are largely young Black and Latino males. How do you account for that in New York City? It's because in certain neighborhoods, the Upper East Side, the Upper West Side, the Village, Chelsea, Williamsburg, Park Slope, college campuses, apparently possession of marijuana is viewed as socially acceptable behavior. But in other neighborhoods, such as the ones that I represent in Bedford-Stuyvesant or Brownsville, East New York, Coney Island, parts of the Bronx, Southeast Queens, North Shore of Staten Island, the same possession of marijuana apparently is criminal behavior. And the dividing line in those neighborhoods is race. And so we are branding people, hurting their ability to move forward in a whole host of ways and pursue the American dream for doing the same exact thing that others are doing with respect to marijuana with no justification other than race and socioeconomics. So, Mr. Chairman, I would just encourage you, I support the underlying bill and Representative Gates' efforts here, but this really is an urgent situation that needs to be addressed before there can be any really meaningful floor action in this Congress. I yield back.
With the gentleman yield.
Sure.
I hear you, and my offer is bona fide. We will work on some kind of language that covers simple possession without other related offenses, and that would not be considered a felony in one place. And we recognize the problem you see in New York. Similar things occur in other places, but then also different things occur in other places. We've got to find some language that encompasses that. I do not believe drug-related misdemeanor covers it, so it's got to be something different than that, but we'll find it. I'd like to get to a vote, but for purposes of the gentleman from California, seat recognition.
Move to strike last word.
Gentleman's recognized for 5 minutes.
I support the intent of this bill, but I just note that we shouldn't be having this fight at all. We don't make alcohol manufacturers go ahead and show that somehow alcohol is medically beneficial to you before we legalize alcohol. There is really no evidence that marijuana and cannabis is any more dangerous than alcohol. It is completely irrational that we're spending taxpayers' money at the federal government level trying to eradicate marijuana, trying to prosecute marijuana offenses. This whole thing is just sort of stupid. We need to make sure that we legalize cannabis at some point. This is a step forward. I agree with everything the ranking member has said. I share his concerns. However, the author and the chairman of this committee have said they were going to work to address those concerns. I'm going to give them the benefit of the doubt. I will vote yes on this bill. And if the concerns are not addressed, there's another opportunity for a floor vote, which I may vote differently. With that, I yield back.
The gentleman from California, Ms. Bass, seat recognition.
Gentlemen? Thank you, Mr. Chair. Let me just associate myself with my colleagues in raising the concerns. And I just wanted to point out just a little irony, because I know that shortly we will be talking about the Second Chance Act. And one of the consequences of many of our drug laws have been that people essentially are banned from the workforce. In the state of California, for example, there's 56 occupations that people cannot apply for licenses, one being a license to be a barber if you have a conviction. So while we are going to shortly, I believe, reauthorize the Second Chance Act, here we're talking, ironically, about prohibiting people who have convictions from working in the industry. So I appreciate Representative Gates and the chair in saying that you will work on this to remove that restriction or change it, because we don't want to pass and reauthorize the Second Chance Act and then continue to make the same mistakes by banning people from employment in this industry. Thank you. Yield back.
Are there further amendments to H.R. 5634?
Mr. Chairman.
For purposes, the gentleman from Maryland, seek recognition.
Move to strike last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, thank you very much. As a co-sponsor and a supporter of this legislation, I want to restate the importance of what we're doing here, even though the bill itself is exceedingly modest in its scope and intention. But, Mr. Chairman, marijuana prohibition, like its historical precursor, alcohol prohibition, has proven to be a miserable failure at every level in terms of the criminal justice system, in terms of public health, in terms of public education. And it has criminalized millions of our fellow countrymen and women. It has corrupted police departments, and it has drained away, siphoned off billions of dollars of funds that could be used to fight real violent crime, political corruption, and other offenses that actually harm the public good. Now, Congress is way behind the states here. 30 states have decriminalized marijuana or legalized marijuana or enacted medical marijuana programs. In my home state of Maryland, we adopted a medical marijuana program, and we have decriminalized marijuana. And I think that there are tens of millions of Americans, maybe more than 100 million Americans, who live in jurisdictions that have left Congress in the dark ages here. So as usual, the states are leading, as they led on any number of reforms in our past, whether it's child labor or minimum wage or women's suffrage or direct election of U.S. senators. The states are where the action is, and the states are way ahead of us, and Congress needs to catch up. Now, in the work that we did in decriminalizing marijuana and passing a medical marijuana program in Maryland, one of the constant refrains that we would get from people was, well, there's no federal study that has shown that marijuana is safe, or in the case of medical marijuana, that it actually helps the people who are desperate for it, people suffering from AIDS or multiple sclerosis or breast cancer or nausea, sickness, or any of a number of other illnesses where people came forward to say that this is desperately needed. And so we obviously need to pass this legislation in order to expand research capacity at the federal level. Now, we've tripped up on this point, which was a point also that we arrived at in Maryland at numerous junctures, which is people saying, well, if there's a new gold rush around marijuana, if there's a whole new industry sprouting up, if there are going to be billions of dollars to be made, if there's going to be tens of thousands or hundreds of thousands of new jobs created around the country, as there have begun to be, we should exclude anybody who had a marijuana conviction for simple possession or anything else. And I went back and I looked at prohibition, and I looked to see if after the disaster of prohibition, which created organized crime in America, if after that, when alcohol was legalized, whether there were bans put in place on the involvement of anybody who'd been convicted of bootlegging or any other alcohol-related crime. And we couldn't find any anywhere. It simply wasn't done. So why would we say to the people who arguably are probably the most expert in the commerce of it that they can't be involved in any way? It doesn't make any sense. And really what it is, we can see, is a perpetuation of the mentality of the drug war, which has failed our country and which has made millions of our own people into enemies of the state. So it makes no sense. So I am glad that there appears to be some kind of agreement to work out the language here. I thought that that was the purpose of the markup, and I would hope maybe by the end of the session today, since we've got a bunch of other bills, we could fine-tune the language, as the chairman says, and bring it back so all of us can participate in it. But this is legislation that we need. It's the very least that can be done at this point. Marijuana prohibition has been a disaster for our people. The states have moved away from it. The people have moved away from it, and it's time for Congress to catch up. I yield back.
Mr. Chairman.
We're still considering the Labrador amendment, and I neglected to call for a vote on that. So let's do that. Then I'll recognize the gentlewoman from Seattle, since I don't think there's a lot of controversy. All those in favor of the amendment offered by the gentleman from Idaho respond by saying aye. Aye. Those opposed, no. The ayes have it, and the amendment is adopted. For what purpose does the gentlewoman from Washington seek recognition?
Move to strike the last word.
The gentlewoman is recognized for 5 minutes.
Thank you, Mr. Chairman. I want to echo and associate myself with the comments of Mr. Raskin, Mr. Jeffries, our ranking member, with the concerns around the bill. I also want to just say to Mr. Gates that I really appreciate your bringing this forward. I appreciate all the work you did on this. I remember when we both first came into Congress, this was one of the issues that we both were excited about working on together, and I think that we are just so close to being able to move something forward that we agree with. I will say that in my home state, which has legalized cannabis, and initially it was controversial. It was passed primarily with Democratic support for the initial recreational marijuana piece. Then when we went to medical marijuana, everybody saw what a boon it had been to their districts in a number of different ways. And then we had bipartisan support. We've now implemented work around research as well. And in our state, we actually put into place a system which is far from perfect. It's not what I would have wanted if I were just writing the bill on my own, but it's a system that bases licensing on points. And the points licensing system looks at the type, number, and dates of crimes that have been committed, and then it allows for some leeway around, because it's based on the total number of points versus an individual crime. I don't think this is a perfect system, but it is an interesting model to look at, because at least it says that if you committed one crime, and I really want to associate myself with our ranking member's comments in particular that none of these things should be barriers. But at a minimum, we should be allowing for some flexibility around this and recognizing that there really is a difference between multiple crimes that are committed, what kinds of crimes those are. Were they committed 15 years ago and you're banned for life? I mean, is there any redemption here for somebody who has been penalized by the system, disproportionately burdened, as Mr. Jeffries has said, and then is now barred from, for life, participating in the economy of this industry and of the research that we're talking about here. So it's not a perfect system, but I guess I wish that we were agreeing on this language today because we would all like to support your bill. I think it is an important piece of legislation. However, I won't be able to support it in this form that it's in because it includes this very detrimental statement to an enormous group of people that have already been disproportionately burdened and frankly has nothing to do with, as has been pointed out before, the quality of the research and all of the things that we're trying to do. And I do believe that my colleague from Florida understands that very well and knows that our intention here is to do this together and to really be able to put our bipartisan stamp on this. And I think you would get that if we could just address this little piece, which is not so little in terms of the consequence to millions of people across this country. So again, I think that as we reauthorize the Second Chance Act, I think we have to be more forward-thinking about how we address employment in this field. I don't think that we can continue to put forward these harsh policies that actually hinder successful reentry and employment for people with felony convictions. And I hope we can address that today in committee rather than saying, well, let's wait before it gets to Rules Committee. It would be great if we could bring it back since we have another however many bills we have to mark up today. I thank the gentleman from Florida again for bringing this forward. I wish I could support it in its current form. I would be happy to support it if we can address this issue. Thank you, Mr. Chairman. I yield back.
Reporting quorum being present, the question is on the motion to report the bill H.R. 5634 as amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. No. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 67.